Okay. Welcome to the Gender and Migration Unit at NOVA Refugee Legal Clinic. Today we are welcoming Dimitra Fragkou and Kallini. Dimitra is a fellow colleague at the NOVA Refugee Legal Clinic, and she's also a PhD student at NOVA School of Law. And Leah, she's the head of the Legal and Integration Department at the Intervolve Irida Women's Center. Ladies, welcome very much to our Zoomcast. We are talking today about the Greek asylum system and also women's protection. So if you'd like to introduce yourselves a little bit more and talk about the asylum system and protection, I thank you in advance for your time. Thank you so much.
Hello, Tatiana. Thank you very much for the invitation, and I am honored to participate here tonight in this discussion. And I would like also to thank the NOVA Refugee Law Clinic for this great opportunity. So I would like to just explain that today I would like to speak about the Greek law, and Greek law is divided into two sections, two parts, let's say. The Greek asylum law is a different procedure in the islands, the Greek islands of the Aegean, and a different one in the mainland. So my presentation is going to analyze mostly the irregular fast-track border procedure, which I believe that it is a pilot project in the new in how the common European asylum system is going to progress in the future. And I pass to Leah to introduce herself.
Thank you for the invitation as well. I'm also a lawyer. I specialize in refugee and migration law. I worked in the private sector for many years, and since 2016, I work in Northern Greece with the UNHCR. So I have a great experience working as a protection expert in camps, in detention monitoring, but also in the reception and identification service in Athens. Nowadays, I'm the head of legal and integration in Irida Women's Center. It's a center specialized in the protection and integration of women, refugees and asylum seekers in Greece. We are serving now over 450 women, and it's a great opportunity to speak a little bit about the asylum procedures in the mainland, but also challenges that refugee women are facing in the process and after they are being recognized as refugees here in Greece. So Dimitra will start now the presentation with the procedures in the island, which is the entry point for asylum seekers here in Greece, and then I will continue what happens when they arrive in the mainland.
Thank you so much to both of you. Thanks.
So if you don't mind, Tatiana, I would like to share our screen now.
Sure, sure.
I would like to start with a small overview of the asylum framework in Greece. Before 2016 and the EU-Turkey statement, there were relatively very few legal provisions and very fragmented legal provisions for asylum. Now, in 2016, and the 20th of March, there was the first law that tried to incorporate some of the EU recast directives in the Greek legal system, was Law 4375 of 2016. That it was also the first legal instrument that enforced the pilot, let's say, fast-track border procedure in the Aegean Islands. After that, the first amendment was in 2018, which somehow introduced changes in the vulnerability assessment. The vulnerability categories were different, and we can discuss a little bit about that, although it does not concern that much our topic for today, that is the protection of women. And the biggest amendment was Law 4636 of 2019. It was last November, which is codifying and amending the fast-track border procedure, and it is also an implementation of the Reception Procedures Directive. And since then, we had a new amendment during this March, the law 4686 of 2020, that is amending all over again the law. And I would like to stay on these changes because, as you can also observe, we're talking about a different legal framework each year, which leads to much confusion, and it includes lots of technicalities. So it is very difficult to follow up on the changes of the law. Also for lawyers, but most importantly for the refugees themselves and the asylum seekers themselves who are getting lost in information. So since the EU-Turkey statement of 2016, the Greek territory is divided in two parts, as we said, and the islands of Eastern Aegean and mainland Greece. And we have two completely different frameworks, procedural frameworks for the asylum and the reception of the asylum seekers. So, yes. I would like to briefly explain what is happening in the Greek islands since the entrance of an undocumented migrant in the Greek territory. So we have seen the pictures of people are coming with boats, and they are rescued. They have to be rescued by Greek Coast Guard according to the requirements of the law of the sea. So when they enter the Greek territory, they're getting in the closest island, and they're transferred to the local police station or unit where Greek police and Frontex fingerprint them and run their data in Eurodac. This was, I would like also to pinpoint that this was the procedure until procedure introduced in 2016. And there are amendments, but not so much in this framework. So people come, and people were coming, and there was an immediate order for deportation. And then there was a provision that pregnant women 2 months before labor and 6 months after childbirth were exempted from deportation. And in the meantime, with the same order for deportation, there was a restriction of movement. So what is happening is that when people arrive, they're getting a restriction of movement immediately, and this first type of restriction of movement was considered to be an alternative measure to detention. Afterwards, the people are transferred to reception and identification premises, center premises. So what is happening there is a verification of name and nationality, and people are registered in the reception and identification service. And there is an age assessment for minors. There is the medical examination that takes place, and the people are supposed to be given information of the procedure of international protection. And therefore, for a period of 45 days, plus 3 at that point, there was a restriction of movement inside the reception and identification center premises. After that, when this procedure was completed, the cases of people who requested asylum, because those who were not requested asylum, they were getting back to detention immediately. But people who requested asylum, their case was transferred to the regional asylum office for further registration, and their asylum interview was scheduled. Until the decision on their asylum claim, the movement, moving from the island and getting, for example, in the mainland, is prohibited unless the asylum seeker belongs to a vulnerable category. And some things I would like to also mention about how this assessment is done is that it has a very big participation. To a large extent, the vulnerability assessment and the asylum interviews are conducted by the personnel of the European Asylum Support Office, which by order of a Greek state, they are present in Greece in order to assist and facilitate the asylum procedure and assist the Greek asylum service. And what is happening in the islands is that there is a separation in 3 categories. It's a further separation in 3 categories of the cases, because now we're talking about the asylum procedure per se. So people who are from Syria, pursuant to the EU-Turkey statement, there has to be an exploration, according to this agreement, of whether Turkey is a safer country for them. And in this case, for Syrians, it is only an admissibility assessment that is taking place. So what is explored is how was the situation for the people in Turkey, Syrians in Turkey, and whether there were human rights violations in Turkey, and if there were not, people are supposed to be returned back to Turkey. Those whose claim is found as admissible, so there are problems, there are supposed to be problems in Turkey, they continue to the mainland to a specific unit of the asylum service that is a fast-track procedure for Syrians. Because Syrians are supposed to have a very high rate of refugee recognition. Then there is a mixed assessment for nationalities with recognition rates between 26% and 74%, which is mostly Afghanistan, Iraq, DRC, and other countries. So what is happening is that there is an exploration of whether these people should be returned back to Turkey, and if there are no indicators that they should be returned back to Turkey, they continue immediately with assessing their refugee claim. And for nationalities with recognition rates lower than 25%, which are countries like Cameroon or Nigeria or Guinea, there's only an eligibility assessment, because it is possible that they will not receive any protection in Turkey as well. So now I have included a few statistics, mostly for you to understand what is the situation in 2019, because the situation is much aggravated. There was a 48 increase of arrivals in total in the country compared to 2018. And as you can see in the flow chart, there were almost 60,000 people arrived by sea, while there were almost half in 2018. And out of these people, approximately 1/4 is women. The main countries of origin are, if you see, they are high rate countries of origin with high rate of violence and war zones and widespread human rights violations, as Afghanistan, Syria, and the Democratic Republic of Congo. And what is very, very relevant also to our discussion today is the huge, like the vast difference between the capacity of the reception and identification centers where people who arrive in Greek islands live, and what is the current occupancy. So in total it is 6 times more. No, it's yeah, it's a lot. And what is if you see the numbers, in Samos it is more than 1,000%. So what is very striking with these numbers is that actually the living conditions of the people are a disgrace, because they have to live in makeshift tents inside the bushes. And you can imagine that there is no sanitation, there is no wash, there are not enough toilets. There are some chemical toilets, which is a very imminent danger for women, especially in such conditions. And the last number I have included is the time frame between the arrival and the vulnerability assessment. The first vulnerability assessment, which this is the average. Sometimes it reaches up to 9 months, depending on the people who enter the country. But as you can see, it is approximately 6 months. So people stay in these conditions for 6 months or more without having their vulnerability assessed, which means without enjoying the special guarantees that are recognized and that are supposed to be provided by the EU directives. So the International Protection Act, the law that was introduced in 2019, which made the most of the amendments, changes the border procedure, and it makes it in 5 stages. So at first point, people should be provided information by the information unit of the Reception and Identification Center, or in cases of big flows, police, Coast Guard, or armed forces. Then people are channeled to the reception and identification procedure, where they will have a restriction of movement inside the Reception and Identification Center. There they are registered, they have their medical checks, and there is a vulnerability identification. And then they're referred to the asylum procedure, and they're going to be special rapid response unit. This is a novelty, where cases are supposed to be proceeded and prioritized according to nationality. We don't know if this is going to actually happen, because many times some provisions are in practice not applicable. It's impossible to apply. And afterwards, they will be the people will be referred to other reception facilities or detention facilities if there is a rejection of their asylum claim, depending on each case. What is also important in this law is that it introduces the closed reception and identification centers. So reception and identification centers in the islands were supposed to be closed initially, but in practice, since there is so much of overcapacity, it is not possible. So people were having the liberty to visit the islands, to go to the city. After it was not possible, so it was something that could not be enforced. Then I will proceed very fast to the vulnerable groups. I wanted to say that they're introducing now the closed facilities. That it would be completely unacceptable for people to get out. It will be prohibited. Then let me see. So there we have vulnerable groups. Here you can see that concerning women, we have pregnant women and women and new mothers, women right after childbirth, single parent families with minor children. Sometimes we are also talking about women, victims of torture, victims of rape, victims of PTSD used to be included in the law, but not anymore, and victims of trafficking. And the new category that was introduced are the victims of female genital mutilation, that before it was, if the caseworker was trained, it was a part of the torture vulnerability factor. So I would like to, there is a problem with our session, Tatiana. Now, I included some details and some specifics of how the vulnerability assessment in what concerns women is taking place. Mm-hmm. What is happening is that during the asylum interview, there is a part of questions at the beginning that is dedicated to the exploration of vulnerabilities. And I would also like to pinpoint that vulnerability, according to law, can be explored in any part of the procedure. But sometimes, in practice, we can see that if a vulnerability is not mentioned at the beginning, then it causes credibility issues. So how do the caseworkers explore vulnerability? At the beginning, the guidelines say that if a pregnancy is not visible, then what is mandatory is a positive pregnancy test by the hospital. in the past, it was also acceptable by NGOs. In cases of rape and sexual and gender-based violence, according to the guidelines, the establishment of the facts focuses mostly on before the events before and after the rape. So it is not the proper conduct from the part of a caseworker to explore the events of the rape per se. What should be taking place in this context for the credibility assessments are the environmental and behavioral indicators, and this is something that is forgotten and is not taken into consideration in practice by the caseworkers. And in cases of victims of trafficking, the Greek law accepts as vulnerability only the active cases of trafficking. So past cases of trafficking are explored as rape or as GBV. So this is why we have effusive rates. There are very, very few cases of trafficking reported, which is not always the reality, because Greece is a part of a pathway of traffickers. So many women who were before victims of trafficking or in the route, for example, in Turkey, they are most of the times still victims of trafficking in Greece. And this is a very big issue. And it's also very unexplored. Yes. In the vulnerability assessment, there is a very, I think there is a very big issue with the lack of training of the caseworkers. They do not recognize vulnerability indicators properly, and there are many personal biases that are involved. The women have to say over and over again in different stages of the procedure their stories of their life, so there is not a follow-up, a proper follow-up, and there were incidents of a problematic assessment of FGM because women with former FGM were not considered anymore in danger, which we know now that is not true. And the very few remarks before I conclude my presentation is that women are forced into transactional relationships, which means that the pregnancy provision is used by traffickers, and women are impregnating through sexual transactions and selling the fatherhood to single men in the community. And also domestic violence is an important issue if women are with their intimate partners in such very close, very restricted facilities for many, many months. I would like to, maybe we can continue the discussion in the comments, and I will pass on to Leah. Thank you very much.
Sure. Thank you so much, Dimitra, for your